So, what role does the parenting plan play in custody decisions?
So the custody decision will determine what the parenting plan looks like. The parenting plan tells the parents what the minimum they must do with the other side are. It gives us what the time sharing is going to be on a regular basis, what it is for holidays, what it's going to be over the summer. It also determines things like travel, who can travel with the child, how much notice is needed, if you're traveling out of state, whether out of country, if there are any differences, if there's transportation, whether you're meeting at a halfway point or whether one party needs to come and get the child. If you don't have the child, how often you're allowed to communicate with the child, either by phone, whether that's by text, whether it's by FaceTime. Those are all determined in the parenting plan and let you know what your rights are and what the rights of the other parent are as well.
So, what I'm hearing is everything should be outlined in a parenting plan to help custody or help making decisions moving forward with the child.
That's correct. In a perfect world, everything would be in there. Um, some things will from time to time come up that are not. But if you have a seasoned attorney that's putting together your parenting plan to present to the court, everything that you'll come across will likely be included.
Is it mandatory to have a parenting plan?
Yes, the court's going to enter once they enter their custody decision. It'll be outlined in a parenting plan.
Now, we talk about the court entering a custody decision. Is there any, can custody be decided outside of the court?
It can be. The parties can, of course, always come to an agreement on what they're going to do for custody. However, if you want something that's enforceable, it must be ratified by the court, and the court is always going to make sure that any decision, even if it's agreed to by the parties, is in the child's best interest.
So, this one is one that hits near and dear to many households. How do custody laws handle cases of unmarried parents?
So, for unmarried parents, it's very similar to if you were married. They the same best interest of the factor, best interest of the child factor applies. The only thing was that the father would need to be first determined to be the legal father. If the parties are married, that's done automatically. If not, the father would need to file for determination of paternity. And that can be done by affidavit, it can be done by agreement. If the parties don't agree that the person filing to be the father is the father, then a paternity test will be required by the court.
What explain to me what exactly is a paternity test, or what would the court order as a paternity test?
It's Oh yeah, if it's DNA testing, they'll do generally a cheek swab of the father and of the child, and they will match the DNA to make sure that it's a match and that the father is the child's father.
Is it a good practice for all parties to always request a DNA sample, or is that where do you find that in your practice?
So usually we'll have um, no real need for them. That's usually already determined by a prior legal analysis. The Department of Revenue will do administrative cases for child support, and they will make a determination about the legal father generally prior to cases coming up for custody, which is where we would generally get involved.